Hello, this is Dr. Michael Hart, the Bill of Rights, Origins. What you will learn in this presentation. You will learn what the Bill of Rights is. You will also learn intellectual and political origins of the Bill of Rights and what is so special about the 21st century in relation to the idea of rights. So what is the Bill of Rights? It is the first 10 amendments to the Constitution of the United States. It is thus law. It is a part of the constitutional law and not a separate document from the Constitution of the United States. The Bill of Rights is also one of the most consequential pieces of constitutional law in American and in all of modern history. It is a source of political battles because its generic language lends itself to multiple interpretations. What are the intellectual origins of the Bill of Rights? First, it's Magna Carta. The Magna Carta, which means the Great Charter in Latin, was created in 1215, and its purpose was to limit the power of the English king and thereby to extend some specific rights to the English nobility. Magna Carta is important because it is the first modern example of constitutionalism, that is to say, the idea that the power of government is not absolute. We also have the idea of natural rights, which emerged sometime in the late Middle Ages, that is to say, roughly between the years 1300 and 1500 AD, so soon after Magna Carta. Natural rights are different from the idea of natural law. Natural law is a much older idea, and natural law simply means that nature is not disorganized. Instead, it is arranged in a law-like regular pattern. But natural rights is a slightly different idea, and it means that there exist in nature certain rights that are attached to at least human beings. The philosophy of natural rights is most prominently developed in the English-speaking world by Thomas Hobbes, who lived between 1588 and 1679, and John Locke, who lived in 1632 and 1704. Both of these English philosophers believed that nature had rights that attached to human beings and that the purpose of government was to protect these natural rights. Therefore, to both of them, government was to play a role in a contractual relationship, and it owed people protection of their rights. John Locke was more influential than Thomas Hobbes in the American colonies and later in the ideas of early United States history. John Locke is not only closer in time to the American experience, he also wrote the Constitution of colonial South Carolina, and so he was more or less well known in the American colonies. John Locke also had a sunnier disposition than Thomas Hobbes and had a better view or a more benign view of human nature, believing that humans were basically good. It's just that they were imperfect and tended to overreact and become overzealous when it came to defending their own particular interests. For this reason, government had to be instituted to make sure that people do not fly off the handle when defending and promoting their self-interests, particularly their natural rights. We also have the English Bill of Rights, a singular document written in 1689. It came on the heels of the Glorious Revolution in England in 1688, which itself was the second of the two-part great revolutionary events in English history in the 17th century. And the Glorious Revolution confirmed the supremacy of Parliament over the monarchy. The English Bill of Rights would later become the most important prototype for James Madison's draft of the American Bill of Rights. Also, the Virginia Declaration of Rights, written in 1776 primarily by George Mason, and the Declaration of Independence, whose primary author was Thomas Jefferson, and that too was written in 1776. Jefferson's most important influence was John Locke, and some of the most important parts of the Declaration of Independence were almost verbatim quotes from John Locke's Second Treatise of Government. There were also political origins of the Bill of Rights. The most obvious one, of course, is the Constitutional Convention in Philadelphia in 1787, which was meant to solve the problem of the weakness of the currently existing government, which was known as the Articles of Confederation. The delegates were sent to Philadelphia to make changes to the Articles of Confederation. However, not all states sent delegates. For example, Rhode Island did not. And for this reason, they couldn't make changes because the Articles of Confederation stipulated that all states have to agree to changes, and otherwise changes could not be made. Therefore, a number of delegates simply left the convention, but those who stayed decided to simply go ahead and replace the Articles of Confederation. The convention lasted from May 25 of 1787 to September 17th of 1787, and on September 17th, the Constitution of the United States was signed, and there were 40 signatures on that constitutional draft of the original document. 39 delegates and one secretary signed it. James Madison was the primary writer of the Constitution of the United States, though he was not the primary author. There was no primary author of the Constitution. The Constitution is a constitution of many minds, and some minds who have contributed to the Constitutional Convention were certainly not there. A perfect example is Charles Montesquieu, who actually bequeathed to the Founding Fathers the idea of separation of powers. Separation of powers runs through the entirety of the U.S. Constitution, but particularly the first three articles. The first three articles are dedicated to three separate branches: legislative, executive, and judicial. And so also the Constitution was a culmination of different compromises, that is to say, plain old negotiations that led to the kind of wording that different sides to an argument could accept. And some elements of the Constitution were original, but not all of them could be attributed to Madison. So Madison, while he kept copious notes and was the primary writer of the final version of the Constitution, could not be said to be the author of the Constitution. Again, there was not a single author. It's a constitution of many minds and many compromises. But James Madison was well prepared. There's a course on YouTube that you can find called American Revolution by Joan Freeman of Yale University. I'll put a link in the description box if this makes it to YouTube. So if this video makes it to YouTube. And she relates a story about how James Madison, in his notes, says that he studied every government known to mankind in preparation for the Constitutional Convention in Philadelphia. Perhaps Madison was just blowing his own horn a little bit too much, but he was, of course, well educated and well prepared. Madison stood at just 5'4" tall and weighed just over 100 pounds. But in that tiny body burned a mind which was second to none, really, in human history. And Madison's preparation and his organization and his focus, of course, deserve a great deal of praise. So Madison was well prepared, and because of that, he would be entrusted to write the Bill of Rights subsequent to the passage of the Constitution of the United States. Now, of course, one of the objections to the Constitution that its opponents made was that it did not include a Bill of Rights. There were certain rights, not many, they were important, but not many, in the body of the original Constitution. For example, in Article 1, Section 9, Article 1, Section 10, Article 3, Section 2. These rights are not the subject of this lecture, and they're also not a subject of the course on the Bill of Rights. But they existed. Nevertheless, the opponents of the Constitution raised the point that there needs to be a Bill of Rights, that is to say, a fairly specific list of rights that the national government would not be able to violate. And those who were for the Constitution, they were known as Federalists. They did not want to have a Bill of Rights because the idea of the Bill of Rights contradicted the very purpose for which the Constitution was created. The purpose of the Constitution was to create a stronger government than the one that already existed. To the creators of the Constitution, the problem was weak government. And of course, if you have a Bill of Rights, that Bill of Rights weakens the government. They did not want to weaken the government. They also argue that the Constitution in and of itself was already a Bill of Rights because it granted power to the national government, and the power that was not granted did not exist. And so James Madison, who was entrusted eventually to write the Bill of Rights because of his superb knowledge and preparation, he complained privately about having to do so. In a letter to a friend, he complained about the nauseous project of amendments. But he did so, he did write our Bill of Rights because that was a promise that Federalists have made so that some prominent anti-Federalists would stop opposing the Constitution of the United States. And some anti-Federalists kept their bargain. They stopped opposition to the Constitution, and the Constitution was ratified in June of 1788. That is to say, it was officially approved. And Madison, by late summer of 1789, came up with a draft of the Bill of Rights. The Bill of Rights contained 17 amendments. Congress approved 12. It sent all 12 for approval to the states, but the states did not approve the first and the second one. And this is how we only got 10 amendments in the Bill of Rights. Now, what is happening to the idea of rights in the 21st century? First, rights are viewed with greater suspicion or cynicism. Some of you might have heard George Carlin's bit about people not having rights, and I'll include a link in the description box, where he says that rights are a human invention and you don't really have any rights, because when the government really wants to, it takes your rights away from you. And rights are certainly not natural rights, because nature, when it wants to, takes your life away from you. For example, through volcanic eruptions or earthquakes or tsunamis. And certainly because you can tell from the geological and anthropological record that 99% of all the species that have ever existed have disappeared. That's just nature's way. Nature's way is not only life, but it's also death. Everything that lives eventually dies. So natural rights, according to Carlin, is a fiction. He was not the first one to have attacked this idea so strongly. In the late 19th century, utilitarian philosophers based primarily in England, Jeremy Bentham and John Stuart Mill, attacked the idea of natural rights as being a fiction. They denied the rights existed, and they claimed that the idea of rights actually stood in the way of a better philosophy and a better government. And that better philosophy and better government should be based on the idea of utility. What is useful is what is good. And what is good? What is good is that which is pleasurable. And what is evil is that which brings pain. So according to utilitarian philosophers, we should not chase after non-existent rights. We should simply accept that despite all of our differences as people, we all agree that we want pleasure, which gives us happiness, and we want to avoid pain, which brings us unhappiness. That should be the guiding philosophical principle of how to organize society. And in fact, that became, in a modern democracy all over the world, I would say, the driving principle. Most people vote because they expect that politicians that their vote elects would make policies that bring them happiness. Okay, so we try to avoid pain and unhappiness, and we try to pursue pleasure and happiness. And this is how government comes to be, through free elections and fair elections most of the time in democratic societies, of course, which are committed to such elections. And people make their choices based on expected utility, pleasure versus pain. The second point about the Bill of Rights in the 21st century is that new technology poses new dilemmas of interpretation. I have previously noted the Bill of Rights is vague in its formulation, but this vagueness is enhanced by the fact that technologies that the founders could not have even dreamed about are now reality. And we will see later in the course how, in specific cases, the Supreme Court tries to struggle with things like surveillance technology, for example, with GPS tracking, thermal imaging, drone surveillance, x ray machines, internet posts and histories. So, our modern digital society is a kind of society that 18th century minds, no matter how brilliant, did not contemplate. And this poses the question of to what extent is the Bill of Rights relevant, and how can we keep it relevant by interpreting its vague provisions in a way that meshes with realities of our age. The next point is that the 21st century itself is very strange. I mean, it's different from everything that has come before, because technologies are blossoming in this century that didn't exist in previous centuries. They are quantum computing, nanotechnology, fusion power, genetic engineering, and perhaps most significant of all, artificial intelligence. So all of these pose a challenge to not just to the rights that we have, but to the very idea of what it means to be human. And as the century progresses, this, I think, will become more and more of a challenging point. In fact, our ability to exist as humans beyond this century is in question. And with this, the whole idea of individual rights is in question. Already, a number of people have noted, for example, neuroscientist Sam Harris and the business magnate and engineer Elon Musk have noted that it looks increasingly like the idea of privacy, at least as it was traditionally understood, is going to die this century because pretty much everything will be surveilled. You will not be able to escape the big brother, so to speak. And this calls for a whole new questioning, for a whole new interrogation of what rights actually mean in the 21st century.